Thank you, Nee, and good afternoon, everyone. Thank you all for joining us this afternoon. Now, before I dive into my content, I just want to make note, I'm seeing some of the questions come in our Q&A about termination clauses and the other items that need discussed. And I just want to double down to make sure everyone's clear on this really key, biggest takeaway that Nee shared. And that is that now is the time to revisit your employment agreements to ensure that your termination clauses continue to be enforceable, even if you've had them reviewed since that landmark 2020 Ontario Court of Appeal decision in Waxdale that Nee reminded you of. Now, with that said, we are going to speak to some of the questions that you did ask in the Q&A in the Q&A segment at the end of our session here today. But I do want to note right off the bat that termination clauses are technical. There's no ifs, ands, or buts about that. They're technical. And so it really is best that you speak to your employment lawyer, whether that's us or another lawyer that you work with, although we do hope it's us, to make sure that those things are updated and comply with the law. And so with that, let me dive into my content, the first topic being bad faith damages. So as you may understand from that title, I'm going to speak more about dismissals here. And Nee, of course, I'll give you that preview once you pass it over to me. I'm sure I speak for our whole team when I say that we really, truly wish that we didn't have to spend so much time talking about a negative topic like dismissals. But unfortunately, given the ongoing legal developments that Nee discussed and that I'll be discussing, and with the possibility of terminations realistically increasing as we enter a recession, like Laura talked about at the outset, it's just too important for employers to understand these developments for us to ignore them and not cover them in detail for you here today. And so Nee discussed employee termination entitlements in large measure and how significant those can be, particularly where there's not an enforceable termination clause. Years ago, those statutory, contractual, common law termination entitlements that Nee was talking about were really all that most employers had to worry about when they were paying out termination entitlements in the event of a without cause termination. It was only in the most extreme circumstances some years ago that employers would face additional damages on top of those termination entitlements when they're letting an employee go. But in recent years, and particularly in the last year or two, this has really shifted pretty significantly. Increasingly, Canadian courts are awarding additional damages. And this is Canadian courts across provinces. You'll see from some of the cases I'll bring you through that across the country, this is a theme. It's not Ontario only. Canadian courts are awarding additional damages beyond those typical termination entitlements, the ones I just referred to that Nee spoke about. So they're awarding these additional damages because of the way that the employees are treated during the dismissal. So broadly, we refer to those as bad faith damages, hence the title of the segment. But more specifically, they're typically awarded as moral damages, aggravated damages, or punitive damages. And I don't want to bore you with the technicalities here, but generally, moral and aggravated damages are two words for the same concept. And that's a type of damages that are awarded where the employer is found to have breached its duty of good faith and fair dealing in the manner of dismissal, which causes the employee mental distress. In large measure, that's dishonesty or unfair treatment in relation to the dismissal that impacts the employee negatively. To try to simplify it, that's really what it's about. Punitive damages, on the other hand, are a little bit different. They can be awarded for other different types of treatment of the employee, but can also be awarded for that same type of treatment that result in moral and aggravated damages, but it will only be awarded on top of the moral and aggravated damages for the same treatment if the conduct is so significant, so severe that the court believes it's necessary to further punish the employee with punitive damages. Punitive damages, hence the title, hence the name of them, really are about punishing the employer. So it's really important to understand when we're talking about these damages related to the manner of dismissal, we're not just talking about the termination meeting. It's easy to think dismissal, that's the termination meeting, right? That's not all it is. Really what it's about are the broader circumstances surrounding the dismissal. Includes how the employer came to the reason for dismissal, how the dismissal is communicated to the employee in the termination meeting, how it's also shared with other employees and others more broadly, as well as the employer's conduct following the termination meeting, such as in implementing the termination decision and the different compensation and what have you that comes following a decision like that. Now, as I said, the threshold for when these types of bad faith damages will be awarded is getting lower year after year after year. They're being awarded more and more commonly. So given all those societal pressures that Laura did speak about at the outset here, the pandemic-related pressures, the inflation, the inflation rate, the economy, the recession that's upcoming, and so many more, improper conduct in workplaces is increasing. There's no question about it. And that increases the risk not only of employees believing that they're being treated in bad faith when they're being dismissed and therefore alleging that and demanding damages on that basis, But leaving aside their perception, also have managers who are responsible for termination meetings acting in a way that can give rise to these damages because of the pressures that they're facing themselves. Now, just to be really clear, I want you to understand these aren't extreme cases any longer. Like I said before, we see these damages claimed and awarded very regularly all the time. And just in this past November, a couple of months ago, we got a decision from a trial that I had last year in which I acted for a senior executive who was dismissed purportedly for cause following a workplace investigation. And in that case, the court found that there was not just cause for our client's dismissal and awarded common law reasonable notice damages, but on top of that, awarded another $50,000 in bad faith damages, largely based on the employer's dishonesty about the nature and the circumstances of the investigation. And that case is not alone by any means. That's the kind of case we keep seeing. And we're commonly seeing these types of demands for bad faith damages by former employees who sue our clients, our employer clients that we represent all the time. Just in the last couple of months, a small handful of the ones that we've been seeing in these demands or statements of claim that our clients are receiving that we represent them on include an employer being alleged to be responsible for bad faith damages because of an innocent error in the wording of a termination letter that was very quickly corrected just weeks after the termination. Another one because a client hired an employee to support another employee who repeatedly complained of being overworked and having too much to do. And it was because that overworked employee claimed without any evidence that the other employee who was hired to support them was actually hired to replace them. And then another one, the last one that I'll mention briefly, involved an employee who was let go on Halloween while wearing a costume, just because of that, because it was on Halloween wearing a costume. And again, there are so many more. The circumstances where these claims come are increasing and they're broadening all the time. So with the threshold getting lower, with the risk of terminations upcoming getting higher, with the risks that employees, managers in particular, might actually act in these ways that can give rise to these damages getting more and more likely given how they're being impacted by all of our societal pressures, it's so important to understand what you should do and really what you shouldn't do. And so I'm going to talk about these three cases that you see here very quickly. The first case I want to discuss is Pohl and Hudson's Bay Company. So in this case, there was a managerial employee, a retail employee who worked in a retail store, who was dismissed early in the pandemic in about September of 2020 after 28 years of service. And so when this employee was dismissed, they offered the employee an alternative role, a role that they actually had available for that employee. It had lower pay, potentially fewer hours, and the employer required if he wanted to accept that role rather than being let go, he'd have to sign a new employment contract that did have a termination clause, which he didn't have an enforceable termination clause before that. He turned that offer down and he was let go. When he was let go, he was immediately walked out of the workplace. And he was walked out of the workplace, although this wasn't without cause termination. There was no claim that this was for just cause. Now, rather than paying out the statutory termination pay, the statutory severance pay as a lump sum, as the Employment Standards Act requires, it was paid out by the employer on a salary continuance basis. And that was despite a number of requests by the employee's lawyer for the employer to pay it out as a lump sum, again, as the Employment Standards Act does require for the minimum statutory entitlements in Ontario. In addition to that, the employer did not issue the record of employment for the employee until long after the dismissal. So in that case, the employee brought a wrongful dismissal case. They were awarded damages for a 24-month notice period based on their long service and other factors. They were also awarded $55,000 in bad faith damages. $45,000 for moral damages and an additional $10,000 for punitive damages because of really those factors I just mentioned. He was offered that lower role, which would have required him to sign an employment contract with a termination clause. He was walked out immediately. His termination entitlements weren't paid as a lump sum, and the employer was delayed in issuing the record of employment. I'll say these are all pretty common steps that employers often take, often due to innocent mistakes or often due to what we've always considered to be reasonable strategies in the event of a termination. Often, if there's not enough work for an employee, the employer will offer an employee a lesser role as an alternative to being let go. And of course, generally where an employer offers a new role to an employee, they're going to ask that a new contract be signed, and contracts should generally have a termination clause in there. So that's really not that unusual. Employers often walk employees out of the workplace, even when it's without cause termination. And there was not a lot of facts, I'll say, in the decision about exactly what the circumstances were of walking the employee out. But in broad measure, walking the employee out is often done to protect confidential information. It's not necessarily done to embarrass the employee or anything like that. And it's also not uncommon that employers mistakenly issue a record of employment late. It's an administrative process. Sometimes it goes through a number of people, and sometimes that gets missed for a period of time. Similarly, it's not uncommon that employers will mistakenly believe that their statutory termination entitlements can be paid out as a salary continuance rather than as a lump sum. And so that's often an innocent mistake as well. And despite that these are typical, often innocent mistakes, often, not something that would previously be considered a mistake, $55,000 in bad faith damages. So that's a big one that I wanted to highlight to start us off here about how this test really has shifted. Now, the next case that I want to talk about is PASSUP and the Saskatchewan Gaming Authority. And so this is a circumstance where an employee came back to work after being on a disability leave, and his performance started to suffer, or at least the employer alleged his performance started to suffer. So it resulted in a meeting between a manager and the employee, where the manager gave the employee an ultimatum: quit or be fired. And so as a result, the employee had no choice and he was fired. In that case, the employer also alleged that the employee had improperly used the company credit card and the company vehicle that he used as part of his job. And although that ultimatum was found by the court to have been made by the employer alleged that it never made that ultimatum. And in fact, the employee just resigned, and it came as a surprise to the employer when the employee resigned in that meeting. And those allegations about the improper use of the company credit card, the vehicle, about not making the ultimatum, those were all maintained for about 9 or 10 years, which was the period from when it actually happened to when it finally got to trial some years later, 9 or 10 specifically years later. And so the court found again that ultimatum was made, and that the employer was being dishonest when he claimed that was not the case, and that there was no basis for the allegations of improper use of company card, company vehicle. And the court in that case awarded $25,000 in moral damages because of the allegation about the company card and vehicle, which the court saw as effectively an allegation of fraud, an improper allegation of fraud. And on top of that, there was another $25,000 awarded in punitive damages, and that was because the employer was dishonest about the circumstances of the termination, saying they didn't make that ultimatum and the employee really resigned when the court found that wasn't the case. And the last case I want to talk about, I will admit right off the bat here, this one could be seen as more egregious than these other cases I just talked about, but it's an important one to see another type of circumstance that can lead to these types of damages. This is a case called Cho and Cafe La Forêt out of BC. And in that case, the employee, who's a male baker for the employer, was alleged to have inappropriately touched another female employee. And the employer did an investigation, and they did find that the employee did admit to aspects of the allegations of improper touching of the female employee. As a result of the findings of that investigation, the employer did say that they would continue the employee's employment, the employee who was responsible and admitted to some of this inappropriate touching. They agreed to continue his employment, but only on the condition that the employee swear an affidavit, which addressed some of the things that he was found to have done through the investigation. And the court found that affidavit is worded in such a way that it suggested that he was a sexual offender. As you can imagine, that employee refused to swear that affidavit, particularly because there was some concern that the complainant, the employee who made the allegations against him, wanted to go to the police. So this affidavit would have been relevant to potential criminal charges against him. So he refused to swear that affidavit, and as a result, he was fired for cause. And the employer refused to issue his record of employment unless and until he did swear that affidavit that they were asking him to swear. And so in that case, the employee brought a case against the employer in court, and they did, in addition to some other damages, they did award the employee $25,000 in bad faith damages. Remember, again, this is an employee who admitted to improper touching of another employee, and that was the circumstance of all this. But because of the affidavit demand and because of the delay in issuing the record of employment, $25,000 in bad faith damages were awarded against the employer. And so let's go to the takeaways now about bad faith damages. The really key first point that I want to make here, as these cases show, the standard for finding of bad faith in the manner of dismissal is lower than ever. I've said it a few times here, and that's intentional. It's important that you understand that it's lower than ever. And so employers need to be extremely careful in what they do, the steps that they take in relation to an employee's dismissal to avoid these types of damages. So first point there, comply with statutory termination related obligations. What does that mean? That really comes from that poll case, the first case that I was talking about. You should ensure, and not to mention the Cho case, because that related to the record of employment as well, ensure that statutory termination entitlements are provided specifically in compliance with the legal requirements under the applicable employment standards legislation, and other relevant legal requirements, like when a record of employment has to be issued, are complied with strictly as well. Make sure that happens to avoid these bad faith damages because, again, of potentially innocent mistakes. In addition to that, you want to make sure that you're training your managers to conduct employee dismissals with the appropriate sensitivity. And that involves a whole number of things. Really, you should ensure that those who are responsible for conducting these termination meetings are carefully trained on what to do, what not to do in conducting these termination meetings. And a really key point to keep in mind there is that there should always be a second person there for any termination meeting, and there should be detailed notes contemporaneously taken, so taken on the day of the meeting, that are reviewed by both of the employer representatives at that termination meeting to ensure that there is a clear, accurate record of what happened. And again, if an employee alleges improper treatment at a termination meeting, it can result in bad faith damages. We saw that again in that past app case. And in that case, the court found that it happened. It's possible that a court could find, allegations that are not true, that are unfounded, happened to result in those types of damages as well. And that's why it's so important. Have a second person there and take notes. And then, of course, the past app case shows very clearly managers need to be honest about what did happen in that termination meeting, and having that second person there to stand by it is going to help show that. Lastly, you want to conduct your workplace investigations appropriately and exercise caution when implementing corrective action following the investigation. And of course, that comes out of the Cho case that we were talking about. But it also relates to my case that I was referring to, that we got the decision a couple of months ago. It's more important than ever that employers comply with those strict investigation obligations to avoid these bad faith damages at the end of the day. But the risks related to these investigations, they don't end there. They also, again, relate to how the corrective action is imposed, what steps are taken to try to resolve and remediate the situation after the investigation. Because if those steps are improper, as they were in Cho, again, bad faith damages can be awarded. And so I'm going to shift now to the last segment that I want to discuss, and that's quiet firing. So Laura talked about quiet quitting at the outset, and she told you at the outset there's another viral term along with quiet quitting that we heard so much about in August or September, if my memory serves, and that's quiet firing. And so with that, let's jump right into the content. The first thing you need to understand is, what is it, quiet firing? I imagine most of you heard about it. I'm not going to spend a lot of time here, but for anyone who was able to avoid this concept and this discussion for those few weeks, it was so hot in the media. Let's make sure we're all on the same page. So really, it involves employer conduct that's intended to demoralize an employee and drive them to resign from their position. The idea is make the employee's life make their life miserable at work so that they'll quit, so you don't have to fire them. That's what quiet firing is all about. And this can take so many different forms. Some of the common examples are going to include nitpicking an employee's work and performance, or just refusing to give them feedback in the first place, ignoring them, refusing to meet with them, treating them unfairly in all sorts of different ways, whether it's being rude to employees, yelling at employees, spreading rumors about them. A lot of those, by the way, could also be bullying and harassment on top of quiet firing. And one of the big issues with quiet firing is that really, it's going to often constitute constructive dismissal. So constructive dismissal, to give a really quick overview there, again, it's a form of wrongful dismissal where the employer's unilateral actions are deemed to effectively have dismissed the employee, even though the employer didn't say you're fired. And so in the event of a constructive dismissal, the damages are going to be the same for the employee as if the employer did in fact let them go without cause. It's going to be the same statutory termination entitlements and contractual or common law, depending on whether there's an enforceable termination clause. And so that's a big liability that employers face when you're trying to quietly fire somebody. There's a very good chance that you'll have constructively dismiss them anyway. And if you've constructively dismissed them again, those same termination entitlements are going to exist regardless. Now let's go to the takeaways, which I've started giving you there a little bit already. And that's to ensure that an employee agrees to any changes that are going to fundamentally alter the terms of employment. Don't try to force these changes on people, which is really, again, what constructive dismissal is all about, a unilateral change by the employer that changes their job. The costs are significant. Again, it's the same as letting them go without cause in most cases. But on top of those strict financial costs, it's also a huge impact on employee morale, both for the employee who's being impacted, but also the others who are seeing the way that employee is being impacted. And that can be really, really hard to come back from. Again, particularly these days where so many people's mental health is diminished since the pandemic and all the other things that we're dealing with right now. And on top of that, you want to be forthright with your intentions to dismiss an employee. So where the end of an employment relationship is what you really want, it's going to be less costly in most cases, financially, and again, to the culture and employee morale, for you to be forthright about your intentions and just let them go without cause. Rather than try to push them to resign with unwanted changes and changing their work conditions, and again, just making them generally miserable in hopes that they're going to resign, just let them go and take steps, get advice to make sure you take steps to limit your exposure as much as possible. And including, by the way, before you get to that point, making sure you have enforceable termination clauses, as Nee was talking about. Now, the last point I want to make here before I pass it over to Alex is that the potential liability for quietly firing an employee, again, effectively constructively dismissing them, is not just the general termination entitlements, the same as wrongful dismissal. It also can result in awards of bad faith damages, the first point that I was talking about here today, because those types of damages are awarded for exactly this type of conduct, the type of conduct that also amounts to constructive dismissal and quiet firing. All right, and with that, I'm going to pass it over to Alex to bring us home before the Q&A.